quick update on the Chauvin trial. So not Chopin as in Linus from the Peanuts playing, but Chauvin, the Minneapolis, Minnesota police officer being tried now. This week, 12 of the 12 jurors were seated, and one of the two alternates for a total of 13 were seated. There were some motions, 2 motions to change the venue and a change of delay. The defense actually asked for a 6-month, 9-month delay because in the middle of the week, after outrageously coming out and saying that the city's doing everything, the fix is in. They're trying to do everything they can to convict this guy. And I make this point at the very beginning. Whatever my personal problems are with the system, it does not repair the system by taking this guy's rights away by fixing the trial against him as much as possible. So they're doing everything they can to get this case resolved, to either win or lose before riot season begins, because it's still cold up there. So they're pushing forward, and of course all the favor goes against the defense for the prosecution. So one of the things that the city did is they decided to come out and announce that there was a $27 million settlement for the George Floyd family. Now they did this, of course, in the middle of the trial and in the very beginning of the trial to kind of like tank the jury pool. So the defense asked for a delay of trial of 6 to 9 months till time went by, and a change of venue, meaning take it out of Minneapolis and take it to another part of the state. They were shot down on both of it, on the most ridiculous arguments that I can make. And just to take it back a step, because I forgot to say that, of course, they did this deliberately, even though they came out, the city mayor and their city council came out and did deliberately, because a year before, of course, to prevent riot season, they waited till after the trial. And if they were it's not even a final agreement that they came out announcing this $27 million. It's in the beginning part of it. There's been some agreement, but not a final agreement. So they did this specifically to tank the jury pool. And the judges' protestations are just creating complete appeal issues. Not like there aren't enough already. This is already one of the most cluster F trials I can possibly imagine. But his reasoning was, well, there's no part of the state that would be better. Of course, every part of the state would be better than the center part of the city, because every part of it is going to have conservative jury pool, which would be pro-cop, which would then probably exonerate them. And then no part of the state is actually heard about this. Well, again, if in it, he actually put on the record, the judge put on the record that he didn't believe that anybody would really care about the $27 million. Then they polled the members that they picked. I think they picked 6 or 7. This is in the middle of the week, and 2 of them said, "Yeah, completely changed our position." So if that wasn't a reason to appeal before that, after he did that and then put it on the record, this case is going to be appealed no matter what. As it is, the 3 charges are second-degree murder. The idea of second-degree murder is if you're committing a robbery and you don't even intend to kill somebody, or you're committing a burglary, but both of those are felonies, any kind of felony, and somebody accidentally dies, that's felony murder. So they're going after that, and not that he was committing any crime in this. It's ridiculous. That's going to be thrown out in appeal. There's no way that second-degree murder is going to be upheld. Then there's the third-degree murder, which is still another grab bag from first-degree murder, saying that, yeah, they're not saying that he knew him beforehand or personally did it. So you have this third-degree murder where they're not going to be able to sustain that, because, of course, there was a manual saying that you could use this technique, and there's pictures of the manual apparently, and a lot of this is being suppressed by the press because it's anti their narrative. But apparently, the Minneapolis police had a procedure where they allowed this type of hold, maybe not for 8 minutes, but there was 100, maybe 100 of these. There was no other deaths of these. And even, and this is the thing, even like the 8th Circuit Court had okayed a similar incident, saying you could not sue the police officer. Because remember, we talked about qualified immunity. It made it all the way up to the 8th Circuit for a similar case where the restraint was for 15 minutes and killed the person, and that family wasn't allowed to sue the the police officer. So there's no way they're going to be able to make out murder. And if they did, how are they going to square that circle where literally a circuit said it was okay to cut off the artery of an individual being arrested for 15 minutes, where this guy did it for 8 minutes. They can't. So that's not going to survive. So I mean, all their hopes is on this second-degree manslaughter charge, which is like voluntary manslaughter in Pennsylvania. I mean, it was 8 minutes, but it appears that the defense is going to be. There was a lot of back and forth about getting in apparently it was a 2019 incident too, almost eerily the exact same thing with George Floyd, where he's confronted by the police officers. He swallows a bunch of the drugs trying to hide it, claiming all kinds of different things. Oh, I can't breathe, I can't breathe, I can't breathe. I have all these various problems. And then he nearly overdosed, and he's told by a doctor that hey, you have a heart problem. If you keep doing these drugs, you're gonna have a heart attack, right? So now the judge is trying to do everything he can, because of course they're always pro prosecution, to keep that out. But there's no way they can keep that out, because you can cross-examine somebody with a postage stamp. It's not George Floyd that is in the defense seat right now that you can keep out prior bad acts. He is with the case. He's associated with the case. But he's not the defendant. It's the defendant's bad acts you can't get in, and that's the 18 prior complaints against him, unless there's some connection. You can show modus operandi, which there might be, but we don't know. We haven't seen that yet. So the judge, just giving more reason for another appeal on this case, is trying to keep out some of it, but of course he's not going to be able to keep this incident out. And it looks like the defense is going to link that up, this prior 2019 incident, up with the with what they do have some evidence of, which is they have DNA in the back of the squad car this time. Eerily same incident. He's confronted by police. He's taken to the back of the squad car. He's claiming everything under the sun. Oh, you scared me, blah, 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 all this other stuff. And then it looks like they're going to try and argue that there is enough evidence to say that he was swallowing the pills too, and that he caused the overdose, because this is what he does when he's confronted by the police. And so to that effect, because a lot of this information has been suppressed because it doesn't fit the narrative, right? They have like a pill in the back seat, they got DNA in the back seat, and they got like saliva, I think, in the back seat, and some kind of like a picture of him having some kind of pill or something in his mouth. Enough for them to make the argument that really, it wasn't even Chauvin and his hold. It was this is what he does when he's confronted by the police. He overdosed by accident. And then they could say, well, yeah, but even still, though, you shouldn't have used this hold on him for that long. And that's where you can see where there's going to be an argument about very voluntary manslaughter. This second-degree manslaughter they have, whether that's going to be enough, because the jury might just cut the baby and say, kick out the second and third-degree murder and just go with the voluntary manslaughter, which could be a misdemeanor, 1 year in jail if it was in Pennsylvania. If it was like improper defense, that's what we'd be facing with in Pennsylvania. Now the jury was picked again. This is a weird case in the sense that they outsourced the prosecution. These are not the DAs, and you're not your typical DAs. These are scumbag plaintiffs' attorneys trying this case. And I guess the idea is like somehow they're going to do better than actual DAs. No, they're not. Okay, you really need. This is one of those areas. You got to know what you're doing when you go do it. Okay, it's not one of these things you can just pick up like they do in Suits. All right, it's not a real thing, right? You really got to know what you're doing. You got to have experience doing it. The defense attorney is an experienced guy. Does a lot of DUIs, and actually, I've actually won the first-degree murder case and a DUI, and they're about the same. Nobody's going to let you win a DUI. So that's not saying anything. So, I mean, yes, DUIs can be the lowest thing on the totem pole that you for a defense case. But in this case, because of the toxicology, he is well suited to this defense. And going through the 12 jury picks, the jury pool wound up to be of the actual people sitting for the case. Remember, there's 12 for the jury and 2 for alternates in case something happens to one of the 12. You have 5 males and 7 females. You have 6 of white and 6 of color. Of that, there were 4 black males and 2 2 girls of color. There seems to be the biggest group would be 3 elderly white ladies. Of the actual jury pick, and I'm going, when I go through these 12, I'm thinking that the defense attorney, this guy is he's really stolen the lunch pail of the prosecution, because the people of the prosecution, and some of this is more art than it is science, because like the first juror is a white male chemist, right? And he supports Black Lives Matters because all lives matters. Then he comes out and he says something like, well, I never saw the video of the George Floyd. And then when he's pressed on that, he says, well, I saw a picture. Now, come on, this guy's obviously lying. So nobody really knows which way he's going to go, except that he is a white chemist. So it means he's pro-police, right? Because that's you're conscientious, you're following the rules. It's not anything, chemistry is not anything, you're a rule follower. It's not anything like creative in that. And it means you're making a lot of money. So you're probably pro-police, you're pro-order, right? But when I go through these, like it's hard to tell. When I see number 4 as a black male, and he's an immigrant, all right, now I know exactly who he's going to be for. He's going to be for Chauvin, because he's going to look at George Floyd, and there's this is what they're, in the falsity of the left movement. This is something they don't bring out. There's a huge difference between African American, people from Africa that are immigrants, much more closer to our Italian grandparents, than they are. If you ever talk to, and I have lots of these clients, these are my people, as much as the regular African American people are, they are, they look at, domestic, naturally born American black people as the reason why everything's wrong with America, spoiled, criminals, all the rest of it. They're the most racist people towards other, blacks that you can ever run into. And we'll have one of them on the jury. He's going to be sitting there going, the police officer was right. George Floyd deserved that. I mean, I guarantee you that's what he's going to say, because I've tried these cases. I've made that mistake of putting him on the record before, putting them on my jury panels before. So, and then you see another guy, the other black male is a banking guy, and he says he doesn't believe that Chauvin had intent. All right, well, if Chauvin didn't have intent in this, he's already made that decision. Yeah, you could sway his if you're a great and these plaintiffs attorneys, they think that they think they can talk people into anything, right? So yeah, you could put enough evidence on there where you could sway him back towards believing that Chauvin has put intent. But everything in the criminal world is intent. Everything is intent. What's his criminal intent? And if he's already thinking that at the time when all you have is the leftist, liberal party, the Democrat news party, the corrupt media news narrative, and you start showing things like to this guy that there's a Minneapolis manual that not only okays this chokehold, but tells you how to do it, and you're supposed to turn it on the side. So the only thing he didn't do was didn't turn it on the side. That there's pictures of them being trained like this. Then this guy's probably this guy is definitely going to vote for an acquittal. So even though the fix is in, again, why we have jury trials is because it stops the state, it stops the fix, and right now it looks like the defense, even though they're being forced to go forward with this, and being pushed forward, the smart thing would be, the right thing would be to do was because these jerk offs in the in the Minneapolis mayor's office and city council want to tank this, is to wait 6 months, 9 months, and see if they let it calm down a little bit, and see if people forget, and see how tempers do it. But you have to have the lynch mob, and they got to gin up the next offense to be outrageous about. And the way it's going now, it's going to be probably an acquittal of Officer Chauvin. Now, should he have been my problem with the system is that, number one, he should never have been a police officer. He should have started in the jail. he would have been weeded out in a year of the jail, and then as a correctional officer, and then maybe as a police officer. And if he still is having all these incidents, then he shouldn't have been then a police officer. So I'm not saying, I'm not trying to condone this in any way, shape, or form. Misdemeanor manslaughter, that's something you could prosecute him on. Involuntary manslaughter or voluntary manslaughter for a felony. So he takes the felony and his record's ruined for the rest of the year. He gets out of jail, or he takes the misdemeanor and spends a year in jail. I mean, that's what it would be in Pennsylvania. But it doesn't, like I said in the very beginning of this, it doesn't do the system good. You don't fix the system by taking his rights away, even as he is. Even if he's the most guilty, heinous person on the planet, he deserves his due process, because otherwise it ain't due process. And so that's our Chauvin
All right, brother.
update.
Well,